The Supreme Court just wiped every gun permit off the map. Concealed carry licenses, purchase permits, ownership cards, all gone. This isn't about faster paperwork or lower fees. This is the full abolition of government permission slips for your Second Amendment rights. The permit system, as we've known it, is finished. If you want to know what this actually means for gun owners in your state and how your rights just changed overnight, subscribe now, because what happens in the next 90 days will decide the future of gun rights in America for generations. The court is hearing an emergency case that asks one question: can states force you to get a permit to own or carry a firearm? Out of thousands of appeals each year, only a handful get fast-tracked. This is one of them. 27 states already have constitutional carry. No permit, no fee, no wait. But 23 states still force you through a system that costs between $150 and $800, takes weeks or months, and lets a bureaucrat deny your rights. Your freedoms change depending on which side of a state line you stand on. The legal argument is brutally simple. You can't make a constitutional right contingent on government approval. Imagine if your state said you need to fill out a form, pay $300, take a class, and wait 8 weeks for permission to attend church. We'd call that insane. The Second Amendment is supposed to work the same way. Federal appeals courts started ruling in opposite directions. Some said permits violate the Constitution. Others said they're perfectly fine. Same behavior as a protected right in Texas and a felony in New York. The Supreme Court exists to stop that kind of constitutional chaos. Here's what nobody's reporting about how this case reached the court. A federal judge just struck down an entire state's permit system, declaring it unconstitutional on its face, meaning no tweak can fix it, the whole thing has to go. He scoured every historical record from the founding era through the early republic and found zero evidence the founders ever required permits to own or carry firearms. People simply exercise that right without applications, fees, or gatekeepers. Then he uncovered something anti-gun groups never want discussed. Permit systems only appeared in the early 1900s, and the real motivations were openly racist. Southern states created them to disarm Black Americans after Reconstruction. Northern cities used them to keep guns away from Irish and Italian immigrants. These weren't safety laws. They were discrimination tools disguised as regulation. The state appealed, confident they'd win. Instead, a 3-judge circuit panel upheld the injunction to Quan and wrote an opinion that demolishes the entire concept of permits. They said requiring government permission to exercise a right is like requiring a permit to go to church. The moment you do that, you've turned a right into a privilege. When the state asked the full circuit to rehear the case, every judge declined. That's a massive signal that the panel got it right. Now the split is official. The Second Circuit upheld New York's permits. The Ninth upheld California's. The Fourth approved Maryland's. Meanwhile, this circuit declared all permits unconstitutional. Federal courts are saying completely opposite things about the same constitutional right. But what really accelerated this case is what happened next at the federal level. The U.S. Department of Justice under Attorney General Pam Bondi has taken a position on gun rights that goes further than any federal stance in modern history. They didn't just say overly restrictive permits are problematic. They told the Supreme Court that any permit requirement whatsoever, no matter how reasonable it seems, violates the Second Amendment. Their logic is airtight. Constitutional rights cannot be made contingent on government approval and fee payments. You don't need a permit for free speech. You don't need a permit to exercise religious freedom. You don't need a permit to be safe from unreasonable searches. So why do you need one to own a gun? They also presented hard data that destroys the safety argument for permits. Texas implemented constitutional carry and violent crime dropped 4% the first year. Florida eliminated permits and saw a 3% decrease. Tennessee dropped permits in 2021 and violent crime fell 7% over 2 years. These aren't projections, they're real-world results. Over 25 constitutional carry states filed briefs, forming the largest state coalition ever assembled for a gun rights case at the Supreme Court. The briefs also exposed that permit systems cost $150–800, which is a crushing barrier for working families living paycheck to paycheck. The people who need self-defense the most, those in high-crime neighborhoods, are the ones least able to afford government permission to protect themselves. The system prices vulnerable people out of their rights while the wealthy face no barriers. But even with all this momentum, anti-gun states are already preparing contingency plans to make this Supreme Court victory meaningless. Sources inside multiple state legislatures have revealed that actual bills are being drafted right now to sidestep the ruling. The strategy is cynically brilliant: change the law before or immediately after the court rules, hoping to make the case irrelevant because the challenged law no longer exists. New York has already pulled this maneuver multiple times. After the court agreed to hear the Bruen case, New York changed its concealed carry law to dodge the ruling. After Bruen was decided, they changed it again to avoid actual compliance. They've perfected the art of legal evasion. California's plan is even more calculated. Sources familiar with the draft legislation say they're preparing to eliminate the formal permit but replace it with a mandatory firearm safety certification. This certification will require the exact same background checks, the same training, the same fees, the same waiting periods. They're literally just renaming it and betting you won't notice. Same gatekeeping, same delays, same denials. Only the label changes. New Jersey's scheme is more insidious. They're considering eliminating ownership permits entirely. Big press conference celebrating Supreme Court compliance, but buried in the bill is a requirement for government approval on every single ammunition purchase. You can own the gun without a permit, but you can't feed it without constant government permission. Every box of ammo requires a background check and potential denial. It's a backdoor permit system disguised as compliance. Illinois is exploring eliminating carry permits but requiring mandatory liability insurance policies that would cost the same as current permits. And here's the genius of this scheme. Insurance companies could simply refuse to offer coverage in Illinois or price policies so high that ordinary people can't afford them. The state gets to claim they're not denying rights. They'll say insurance companies are making independent business decisions, but the result is identical. Most people won't be able to carry because they can't get the required insurance at any reasonable price. Massachusetts is drafting legislation to eliminate permits but require state-approved training courses. Sounds reasonable until you see how it would work. The state controls which instructors get approval. They could ensure all approved instructors hold anti-gun views. They could restrict class sizes and course availability, creating 6-month or year-long waiting lists. You'd have a constitutional right on paper, but couldn't exercise it. Until completing training, the state deliberately makes nearly impossible to access. Every single one of these workarounds has the same core design. Government pre-approval remains, just channeled through different bureaucratic processes. Fees remain, just relabeled. Background checks still gatekeep access. Officials can still deny you based on subjective standards or by making the process so burdensome you give up. The permit disappears in name only. Everything it actually did, delay, restrict, deny, stays in place. Some legal experts believe these workaround bills could be introduced within 30 days of the Supreme Court ruling. That's how quickly this could happen. The court delivers what looks like a massive victory for gun rights, and within a month, anti-gun states have restructured their systems to accomplish the same restrictions under different names. The question is whether the Supreme Court will write their opinion broadly enough to shut down these schemes before they're implemented. They could rule that any system requiring government pre-approval before exercising Second Amendment rights is unconstitutional, regardless of what you call it. Any fee structure creating financial barriers violates the Constitution. Any government-controlled process that delays or denies rights is impermissible. Write it that clearly, and you close the loopholes before state legislators can exploit them. But even if the court writes the broadest possible opinion, enforcement will be the real battle. Some states have shown remarkable willingness to resist Supreme Court gun rulings. Federal lawsuits will likely be necessary to force actual compliance. This ruling might not end the fight, it might just shift it to a new battlefield. So here's what this means for you. If you live in a constitutional carry state, this ruling validates and permanently protects your system. If you're in a permit state, your situation is about to change, but the timeline depends entirely on your state's willingness to actually comply. The states most likely to deploy these workaround schemes are New York, California, New Jersey, Maryland, Hawaii, and Massachusetts. If you're in one of these states, expect immediate resistance and years of legal battles. Research Research your state's current laws and monitor how your government responds to this ruling. Join state-level Second Amendment organizations for real-time updates. Don't assume changes happen immediately just because the Supreme Court rules. Stay informed to avoid legal problems during the transition. This represents the most significant Second Amendment case in modern history, but the real battle over implementation is just beginning. If you want to stay ahead of every development and understand exactly how this affects your rights in your specific state, subscribe and turn on notifications right now, because this is moving incredibly fast. Things happening this week in state legislatures will determine whether this victory actually expands your rights or whether anti-gun states successfully dodge it. Drop a comment telling me what state you're in and whether you think your state will comply or find workarounds.